Okay, the number of attendees seems to be stabilising, so we'll get started so we finish on time. Hello and thanks for joining us today. My name is Guy Usher. I'm a partner in financial markets and products. This is my partner and colleague Dougall Molson, who's also in the partner in financial markets and products. I'm a derivatives lawyer by trade. If you don't know, Dougall's a structured finance lawyer. So this is the third in the last in this series of workshops on digital assets and specifically focusing on cryptocurrencies. And just a reminder, because I'm not sure if everyone's joined all of the shows. The first one was on the technology and some of the features of crypto, together with a sort of regulatory landscape, UK, Germany, France. The second show was on derivatives and also the reg cap treatment, and we shunted repo into this last show, which was going to in any event cover lending and asset-backed notes. So the distinction primarily between this session and the previous session on derivatives is that the derivatives is focused primarily almost on cash settled products, synthetic cash settled, whereas all of the products that we're talking about today have physical components to them, and so that's primarily the distinction. So if you could move on to the next slide, please, just the introduction. So this is what we're going to cover today. As I said, those are the products we're looking at. In the last show, Dougall did talk about crypto-linked notes, whereas this time we're talking about crypto-backed notes. So there's a physical piece of crypto in the structure. And then before we look at the actual products and the different features of those and how the physical aspect plays in, we're just going to talk for the first half, roughly, of this about some of the legal and other issues that arise in the context of title transfer of crypto, security interest over crypto, and intermediation in holding of crypto through custodians. Next slide, please, Jess. And the next slide. Thanks. So we're obviously we're not going to go back through all of the technology and the features of crypto. We're just going to highlight a few relevant points here. But the mechanism by which transfers of cryptocurrency in particular can be made and the possession or control of them established is determined under the protocols embedded by the crypto asset itself. So there is no, and it's decentralized typically in almost all cases of what we're talking about for our subject matter. And so, but what we're worried about when we're talking about transfers of ownership and title beyond possession and control to who owns the asset is necessary to dig a little bit deeper, because the protocols and the chain won't necessarily answer those questions for you, because these are legal matters and they will be determined. So the ownership of the crypto would be determined by reference to applicable law, and obviously it's necessary to work out what that applicable law is in the context of any particular currency. So you need to determine which law or laws govern the property interests in crypto, the ownership, then what the nature of the property interest is under those laws. So having established this, maybe England and French law that are applicable for different purposes, what are those property interests, so those laws that are relevant that attach to crypto, and then under those laws to determine where the crypto is kind of located for the purpose of ownership and potentially security. So the equivalent of the lex situs of the crypto. Next slide, please. Yes. Thank you. So under English law, property interest traditionally have always been sort of one of two types: something that you can possess and something that is effectively called a shows in action, that give you a right against somebody, a particular person, to have something delivered to you, to sue them. It's a contractual claim in effect against somebody. And traditionally, those were the only categories But more recently, other categories have been recognized. They've not been specifically identified, but other assets, not necessarily analogous to crypto, have been found not to be something you can possess, or not something that give you a specific right against somebody. And for example, quotas, milk quotas, fish quotas, they give you a right to do something, and they are deemed to be property for English law purposes, but they don't currently fit within one of those categories, and crypto doesn't fit in one of those categories either. Other laws are more codified than English law as to what types of property interests are available, whereas we are common law jurisdiction and allowing the law greater flexibility in the courts to develop new concepts. And so those may need to change, or may not specifically recognize crypto as a property at all. And I think you'll find that in most jurisdictions, developed jurisdictions, it will have some property characteristic. So that's talking about ownership. And again, the legal transfer, if you like, the change in possession of control is provided in the chain itself by public and private keys, plus the validation by the nodes of the chain about who is the current person in possession and control of that particular piece of that particular block, of that particular currency. Next slide, please, Jess. And then when you say that's talking about transfers, and it's talking about ownership interests, which are not the same as possession and control. In order to answer the question, to look at analyze a pledge, there are additional questions that need to be considered. So in order to answer the question about how you create security over crypto, you need to consider, first of all, the same questions as to ownership, which we've just considered, and then there are additional questions that you need to consider. The first question is how to create an effective security over that kind of property. So having worked out the type of property it is under the applicable laws, what security type is the most appropriate? And there may be more than one available for that kind of property. So for example, under English law, it might be a mortgage or a charge that's available. Then you need to consider how you perfect the security interest. And questions of perfection generally around, other than registration, generally arise around having sufficient possession and control. And that would, for example, determine whether or not you've got a fixed or a floating charge under English law. And then there are all the issues to do with potential set aside and insolvency. So you would need to consider the basis on which a security interest can be set aside because of the insolvency of one of the parties. So in principle, pledge is more complex, it's a more complex bundle of issues to consider than mere ownership. Next slide, please, Jess.
So I'm going to discuss the English law position in a little bit more detail. There are still more questions than answers, I would say, as a matter of English law in terms of what is the nature of property and digital assets, how can one transfer them, how can one take security over them. But the framework is very well summarized in a consultation paper that the Law Commission published in July 2022 for feedback. The feedback period closed in November 2022, and it's expected that there will be some form of report in 2023. I don't think we have a hard date yet. The paper doesn't constitute binding law as a matter of English law, but it's felt that the analysis set out in that paper is likely to be persuasive in cases that emerge in the coming months. And the reason it's felt that would be the case is because the UK jurisdiction task force legal statement that came out in 2019, which started to frame some questions and potential answers in this area, has been referred to in cases since on the question of, in particular, whether or not one can have a proprietary right in digital assets. And as a result, it's clear that the courts are looking to these reports and papers to draw inspiration for how they should be analyzing these questions and what answers should be given. This paper is about 500 pages long, So it sounds like quite a big read, but it's almost like a biblical canon of English legal thinking, and it's probably going to serve as a basis for analysis going forward for the foreseeable future. So what does it say, and what does it recommend? It recommends a recognition of a third category of personal property, which would be distinct from things in possession and things in action, which are the two kind of currently recognized kinds of property in English law. And the idea is to call it something like data objects. Whether or not that will be kind of adopted as terminology or as a legal concept isn't really clear, but it's going to be a helpful way of thinking of it. The main distinction that the paper tries to draw is a distinction between mere information or raw data and what they're calling data objects, which are effectively a combination of data sets and the functionality that goes along with them. So if you think of Bitcoin as strings of data in isolation, those data strings don't really kind of do anything unless you manipulate them, and kind of they use a phrase called instantiation, unless you sort of take an action that does something with that data and forms a so-called data object. And at that point, you have something that's capable of being called property. Now, whether or not that becomes hard law is unclear. It might not matter that much because we already have clear judicial recognition in the UK of crypto assets as something that are capable of being the subject of property rights. It's simply the legal theory behind it that remains somewhat unclear. What the paper says importantly is that the state of the distributed ledger or structure record should not necessarily be regarded as a definitive record of superior legal title to a crypto token. So as Guy mentioned earlier, it's sort of more of a factual matter. But what the paper also says is that factual matter of who is the holder according to the distributed ledger is probably going to be presumptive evidence, at least, of good title under English law, and it may be the only effective evidence. What the paper says, I think, correctly and in line with market practice, is it doesn't make sense to allow participants to have a notional agreement on when title transfers, which is actually the way a lot of the contractual agreements in relation to transfer of property work. The parties agree contractually when title transfers, and then that is perfected or reinforced by some registration or some other perfection step, depending on the type of asset. The position in relation to crypto assets is definitely going to be different as a matter of English law. If you don't actually take the steps to effectively transfer something on chain, then the nature of your proprietary right is going to be dubious at best. The paper also goes on to talk about control, which again, they say should play an important but not determinative role in the overall analysis as to the legal effect of a transfer of a crypto token. But the paper makes an important distinction between control on the one hand and possession on the other, and comes out very strongly in favor of disregarding the notion of possession when it comes to crypto assets, what they call crypto tokens. That is debated. There is going to be a lot of feedback that's already been given, in fact, to the effect that possession is going to be a useful concept in the context of crypto assets, because it would be nice to create the theoretical equivalent of possessory security interests, for example. But it's not clear at the moment which way the wind will blow on that point. Next slide, please. What the paper says quite categorically is that under the current state of law, a trust can exist over a digital asset, and that can be done either with or without an express declaration of trust. There's quite a lengthy discussion of that topic in the consultation paper, and it's a helpful reminder, not just in relation to crypto assets, but trusts actually over any kind of dematerialized asset and the questions that can arise in that context. And in fact, the principles that apply to trusts over dematerialized and intermediated securities, for example, are felt to be more or less equally applicable to trusts over digital assets. And the areas of uncertainties that already exist in that area as a matter of English law are likely to translate themselves into areas of uncertainty under in relation to digital assets. We'll cover that a little bit more when we get to custody. The next thing that the paper says fairly clearly, and I think there's consensus in the market in relation to this as well, that collateral rights or security can be granted as a matter of English law under the current state of law, using things like title transfer arrangements, mortgages, or charges. I mean, this does presuppose, I think, a little bit of a kind of a firmer framework for recognizing what kind of property we're really talking about, i.e. will the data object concept prevail? I mean, the reason that's important is, for example, if crypto assets were viewed as some sort of claim, for example, then you might look at things like assignments by way of security, whereas if they're not really a claim, then you wouldn't do that. You do a charge. But in any event, it seems to be the case that you should be able to do at least something like a charge. At the moment, it's not really clear whether, well, actually, it's probably clear with things like Bitcoin that those aren't financial collateral within the meaning of the FCAR's financial collateral arrangement regulations, which basically means that appropriation wouldn't be available as a remedy under the current state of law. And that would that could create some problems. One could say that a power of sale in relation to things like Bitcoin might or might not be sufficient as a form of remedy. We'll come to that in a moment as well. The Law Commission has sort of said it's not really in favor of trying to extend the FCARs to cover crypto tokens or crypto assets, but the market, I think, is sort of saying, well, actually, it kind of would be helpful, and it might not be that complicated to make adjustments for that to be achieved. Next slide, please. So custody, I'll go quickly through this slide, which sets out sort of the big picture questions and issues that arise in relation to custody, and then we'll drill down into those a little bit more in a couple of subsequent slides. So there is clearly an existing market for custody of crypto assets. So there are lots of both legal frameworks and de facto frameworks for custodians holding crypto directly or indirectly on behalf of end clients. There isn't any harmonized cross-border framework for deciding what law should apply to determine who is to be considered the owner of crypto held in custody. So there isn't for the moment, a functional equivalent of the place of relevant intermediary approach in a cross-border context, i.e. one can't presume, in fact, to the contrary, one really can't presume that ownership of a digital asset will be determined as a matter of the law of the place of the account where it's held. I think there's actually a move away from that in digital assets and trying to actually consider ownership to be something that's determined more as a function of the place where the so-called owner is located or resident. But that doesn't mean that the law of the place of the account is going to be irrelevant. Far from it, because from a practical perspective, any rights against the custodian as opposed to direct rights in relation to the underlying crypto itself, the rights against the custodian will necessarily be a matter of the law of the place of the custodian and where the account is held, because those rights are ultimately contractual rights. But it seems unlikely that it will be sufficient to look at the law of the place of the account to the place of the custodian. It will be necessary but not sufficient. Now, how does a custodian actually hold crypto is going to be a question that needs to be looked at on a case-by-case basis, and the nature of the customer's claim. Was it contractual against the custodian as mentioned, or will there be a direct interest in the underlying crypto? That's going to depend in part on how the crypto is held and on things like recognition of trusts. And then the other thing that and that will require due diligence locally in relation to the legal framework for custody. And the other element that will need to be looked at closely is the regulatory environment applicable to crypto custodians in their jurisdiction and the place where their service is being offered. Next slide, please. So if we go back briefly to the not to the last slide, but just to what the Law Commission report says about custody, what they say conceptually is in the context of digital assets. The holding of a digital asset by a custodian should be thought about as having the capacity to exercise or coordinate or direct the exercise of the factual control of the digital asset. I think that is a kind of a helpful way of looking at things. It's a bit more complicated than thinking about securities that are typically held by custodians, which are in registers, and the legal ownership of which is sort of determined by local law relatively clearly and by a chain of contractual rights against other intermediaries in the chain. I think digital assets need to be looked at differently, and this concept of control is going to be key. What the Commission report says is kind of a good way of looking at things from a common sense perspective, and it can be the reasoning could be applied on a cross-border basis. So clearly, custody arrangements could be based on an outright transfer of title to the custodian, or they could be arrangements based on either contract or trust. And obviously, if a custody arrangement is purely contractual, then users won't have proprietary rights of recourse to any specific crypto tokens retained by the insolvent estate of the custodian. There'll just be a claim contractually against the claim, which will against the custodian, which would be unsecured in an insolvency. But where the market will want to go, obviously, is to find the equivalent of trust-based custody arrangements of the type that exist in the UK in relation to traditional assets. And in the case of a trust-based arrangement with individually allocated custody facilities, then a loss affecting any holding will be borne entirely by the relevant beneficial owner of that individually allocated set of assets, which is probably the best position to be in. Next slide. Thanks. Now, where many arrangements might end up is crypto tokens or crypto assets being the subject of a trust, but held on an unallocated commingled basis, which is ultimately actually how a certain part of this disintermediated securities custody market works. In that case, there's some uncertainty as to the correct approach to apportioning any shortfall losses under English law. But I mean, broadly speaking, this is a question that arises already under in relation to custody arrangements concerning securities. And there's, broadly speaking, a consensus around what the answer is, which is that you just bear the losses pro rata as a pool in the same way as if the people shown as owners in the custodian's records each have sort of a pro rata equitable entitlement. The same outcomes likely to apply to digital assets, but there's probably a little bit of legal uncertainty around that. As a result, the Law Commission suggested that it would be helpful to clarify and simplify the apportionment of shortfall losses in cases where you have commingled crypto token holdings held on trust. Next slide, please. This is going to be a very quick overview of the regulatory framework and where that is going. So at the moment, UK crypto custodians must be authorized under the UK AML regs, and there are examples of institutional custodians who have the appropriate status. In the EU, the MiCA will require authorization for safekeeping or controlling of crypto assets, and similar to the regime that applies to custody activities in relation to financial instruments, but obviously adapted to the specificities of digital assets. Now, currently, there isn't actually a financial services regulatory regime for crypto asset custody in the UK. We don't have a UK MiCA yet, but the UK government is proposing to apply and adapt the existing frameworks for traditional finance custodians to apply them to crypto asset custody activities. So basically, custodians who are today authorized under the UK AML regs would transition towards being authorized under the new financial services regime. And then in theory, they would no longer have to be authorized under the UK AML regs that are captured under the new regime. I think that's all I have on that slide. So I think I'm handing it over to
Okay, so thanks for that, Dougal. Well, that's sort of the principles that we need to kind of get out there before we start then applying it to certain products. And we'll start with crypto lending. Next slide, please, Jess. So lending, much like lending of assets and cash and other things, can make different forms, and the same applies to crypto. So you can do the equivalent of, for example, a loan of gold by loaning crypto, and that may be a deliverable crypto allocated, or it could be allocated entitlement to crypto the same way as you do for gold. You can lend crypto in the same way as you can lend dollars, right? You just change dollars to crypto and you lend the crypto under what is a loan agreement, and you make some consequential changes to that, obviously. And then you can lend crypto as you lend a security, which is typically it's a securities lending, which would normally take place under a GMSLA, for example. And then in any of these worlds, the interest or the fee, if it's under a GMSLA, can be payable in crypto or in a fiat currency. The loan can be collateralized or uncollateralized, and the collateral could be traditional assets or crypto, and it could be title transfer or pledge. So quite a lot of optionality around potential lending activity. Next slide, please, Jess. In the context of lending crypto like lending securities, there is an ISLA white paper that's published in November that identified some of the issues, but at a very high level, to be fair, not that useful, other than it's a useful exploration of the issue, the scope of the issues without actually providing any answers. So interesting read, identifying primarily that these are things that need to be looked at, and that GMSLA would need to be changed in order to allow for the lending of crypto. And the initial focus of ISLA is going to be on digitized securities represented by VLT rather than actual cryptocurrencies. Cryptocurrencies will come a bit later. So this is a bit of a process. So let's leap ahead of them to the next slide, please, Jess. So just to illustrate the features of lending and how some of those concepts that we talked about earlier play out, I've chosen to talk about a title transfer GMSLA, so the traditional GMSLA. Now, there is, of course, a pledge GMSLA, but we're not going to specifically talk about that. We've chosen to break this up so that we talk about the pledge issues in the context of crypto-backed notes. We could have done it here, but we're just going to do the file transfer bit here, and the pledge bit we'll do later under a different product. So in the context of mapping crypto onto securities, crypto becomes your loaned asset, which will be loaned securities. And then there are various issues that you need to kind of transpose or consider and probably make your own arrangements. So first of all, obviously, there's the concept of settlement and deliveries and transfers at inception and at repayment. And let's leave aside the collateral for the moment. So a party could have a crypto custodian, or both parties, or they could hold the crypto direct, i.e. on-chain, which is effectively what we were talking about until we started talking about custodians. The property interests and so on, the pledge issues, we're talking primarily about on-chain direct holding rather than through the custodian, but the two do overlap. So you need to provide what transfer means and how it's going to be evidence confirmed. And I assume, I wasn't actually at the first show, but I imagine that was covered. So this is all the nodes running around and confirming that the actual crypto has moved up the block. It's now somebody else has possession control of it. And that would be on a direct chain Obviously, if it was through a custodian, it would be the custodian moving the asset from an account to another or an account to a direct holding. And then you need to address the consequences and the possible disruptions in terms of delivery failures. Now, people who are used to securities lending will know that delivery failures are treated extremely lightly. And in fact, are not even events of default. You can do mini closeouts and so on, but the actual failure to deliver a security at the inception of a loan isn't normally an event of default, but also the disruptions that can occur may also need to be addressed. You've then got the provisions dealing with margining, so you need to agree how you're going to establish the market value for your crypto and the fallbacks for that. Now, people who know that the GMSLA is quite lender friendly in this respect. Default of agreement, it goes back to lenders in the driving seat, and you may or may not want, or the lender may not even be capable of doing this. So in a securities context, the document is lender friendly because it's to get lenders comfortable to lend their securities out. Query whether that's the correct motivation in the case of crypto. And then you've got things like the frequency of calls. The price variations are happening more quickly, they're happening out of hours, and you may want to be able to call for margin more frequently. And then whether or not you could actually deliver as quickly depends on the type of collateral, which obviously traditional securities is, say, T+2 for many, cash, same day. But actually, if you were delivering crypto as margin, you should be able to deliver it almost instantaneously, assuming you've got the operational setup in place. Next slide, please. Yes. Other things that you need to address in terms of lending in the style of a securities lending are what constitutes equivalent crypto and whether or anything constitute crypto distributions. So equivalent crypto would need to sort of play into the discussion that was made on the digital assets definitions, how you treat forks and so on. Because bearing in mind, equivalent security is not the crypto, it's a notional thing. It's what would have happened if you'd hold it, but you can't assume that the borrower is holding it. So it needs to play out with an answer as to what these things look like in the same way as they do for corporate actions on securities. And airdrops, you could treat them as income, but probably more likely you're going to treat them as equivalent crypto and will just accumulate to the trade. As I said, crypto can be collateral for loans, or it may be traditional assets or even cash. And we'll just talk about that a little bit in a moment. And then settlement netting of crypto obligations in today's world and for some foreseeable is probably not going to be practical. I don't see a way that anyone is even discussing how they could net actual obligations to transfer to net down crypto obligations that are on chain. Now, obviously, if you're using custodians, you could do that potentially, but not on the physical chain. Next slide, please, Jess. I was talking about crypto lending more broadly, and we could have talked about this up front, just for benefit of those who are not perhaps as familiar with securities lending or haven't thought about it. Yeah, who lends and why people lend and why people borrow. Securities, and then the same presumably would largely apply to crypto. So lenders of securities are typically people who are holding long positions, pension schemes, insurance companies, funds being the most obvious types. And they can get a little bit more money. They're going to hold the asset anyway. Why not get a fee on it as long as it's going to come back? So that's the motivation typically of a lender. So somebody who's long crypto. And then the borrowers, who would and why would somebody borrow crypto? Well, it's because they've got a use for it, right? You're not going to get voting rights on crypto. You're probably not going to bet on forks occurring. And anyway, they're probably going to be passed back in any event. So the reason you borrow crypto is primarily because you want to use it somehow. For example, you want a short position. You either want to physically short it, or you want to lend it on to someone else, or you want to short it to create a synthetic. So back to the cash settled derivatives, if you wanted to sell a short derivative, you might physically borrow a crypto and then sell it short to create a hedge. Security financing is typically on a flow basis, so is actually on demand, so it's rolled day by day. You can do term financing, but the main product is kind of just on demand and rolling. So thinking about that in the context of crypto lending and a few other points here, it's lending the lender who, to encourage him or make him safe, is over collateralized. So the value of the collateral provided for the securities is greater than the market value of the securities. But would you want to do that with crypto? Well, I think it depends on who's lending and who's borrowing and how the risk sharing approach. It may well be that the lender is not a good credit, and that the collateral is higher, unless it's crypto, is actually higher grade than the asset being borrowed. In which case you may well want to consider things like negative haircuts on the collateral, so that the amount of collateral provided is actually less than the market value of the crypto, where the volatility market price risks. But in either case, whether you've got negative haircuts or too much, you agree with the traditional approach and over collateralize the position, you've got a fairly volatile asset. The margin is potentially going to be a lot higher than within traditional assets. And so there is an argument that the pledge of collateral may be more appropriate than title transfer from that perspective to mitigate the over collateralization risk that could otherwise apply because of the nature of the assets and its price volatility. But it is more complex to create a pledge, and it is more expensive to operate. So query whether that's going to appeal. Next slide, please, Jess. Some other issues in terms of lending, and I'm not going to cover the regulatory position in any detail, so it's just a very short summary reminder. The current position in the UK is that lending and borrowing of cryptocurrencies, as opposed to tokenized securities, is pretty much unregulated in the UK, other than, as Dougall was saying, the regulation is by way of money laundering authorization, which is applicable to crypto exchanges and dealers and custodians. So the mere lending and borrowing of cryptocurrencies in itself isn't currently regulated, but prospectively and within the next year or so, that could change as cryptocurrencies become a specified investment for the purposes of the RAO and FESMA. So they'll be treated more like securities and emissions, from which point onwards the lending and borrowing of the cryptocurrency would become a regulated activity. Other issues to be considered in the context of lending and repo, and I'll just mention it here under lending, are the enforceability of netting. Netting against multiple positions, multiple borrowings against multiple provisions of collateral. You want to make sure that that can be net down. For some countries, so that will depend substantially on the legal regime, on the insolvency of the person you're dealing with, in case they become bankrupt, which in the UK is largely based on general law rather than there being specific netting legislation to protect and enhance that. In other jurisdictions, it's much more prescribed, the protection that's afforded, and query whether crypto as an asset class or transaction type is covered. In the UK, you do get protection for traditional assets and for netting and collateral, not just for collateral under cars, but currently, as Dougall was saying, that doesn't extend to cryptocurrencies as an asset. So you won't have that. But as everyone remembers, in the UK, at least pre-FCARs, you could still get a positive netting opinion, and certainly there's no reason why you shouldn't get a positive England and Wales netting opinion just because the underlying asset is a crypto. And in the industry opinion coverage, although ISDA is picking up, as discussed last week, picking up cash settled crypto derivatives as a transaction type for the purposes of the ISDA netting opinions, currently no immediate expectation of industry opinions either from ISDA on collateral, where there's physical crypto moving, or on securities financing, or indeed repo. Next slide, please, Jess. So I'm just going to touch briefly on crypto repo, because actually it's another type of transfer trade. The economics and drivers are slightly different, but substantially from a drafting and legal perspective, it is the same as securities financing, and therefore what we talked about on cryptocurrency lending. Next slide, please, Jess. So if you were using a GMRA for crypto repos, it's the same issues: market value, what's a transfer, and so on and so forth. With a normal type transfer like a MSLA, there's just a few things just to bear in mind. The crypto obviously becomes the purchased asset, the equivalent of the purchased security, and you need a purchase price, a cash leg, although query whether that actually could be another crypto leg, i.e. is crypto enough to constitute the purchase to make it a repo. You would typically expect to see heavy haircuts for volatility of crypto if there was indeed a cash leg in a fiat currency. ICMA is not advancing as quickly as ISLA on this. It's expected that ICMA will probably follow the ISLA lead. So until ISLA gets to that point, ICMA will then follow. And then it's expected that ISDA on its SFT definitions will then replicate what those two bodies have done for repo. Next slide, please. I think we may hand over to Dougall. Yes?
Yeah, next slide. Thanks, Jess. So this section will talk a little bit about crypto backnotes, including the structure of them, and then we'll also kind of rewind and talk about some of the legal questions that arise in the context of those structures, and apply some of the concepts we talked about earlier to practical situations. I did talk a little bit about these types of structures in the last call, so I won't go over it in too much detail. But what I didn't do in the last call was kind of explain more clearly the structure of these things. And what this is a little picture of how exchange traded certificates backed by digital assets tend to work. What's interesting about it is you could apply this really to any kind of structured finance transaction involving digital assets as an underlying, but sort of just take out what we call the authorized participants. So how does it work with ETCs? We have an end investor who wants to get some exposure to digital assets without having to worry about custodying those assets themselves. They're interested in getting as direct a real exposure to a real asset as possible, as opposed to something synthetic. So then we go to the right-hand side of that slide, and how do they get that kind of real exposure? Well, they get it by getting exposure to an issuer who's actually holding the underlying crypto assets in its own name, with a custodian acting on its behalf. Security is granted over those, over the custody account and potentially over the underlying crypto itself, in favor of a trustee who acts for the benefit of the end certificate holders. In the middle, in the ETC market, you have, which is a bit like ETFs, you have authorized participants who would be kind of wholesale market participants who would take the orders from investors, and they will source some sort of crypto on the market themselves or out of their own holdings, and then they'll deliver that crypto into the issuer's custody account once they've received the requisite funds from the investor, and then the investor ends up getting a kind of a pro rata entitlement to a certain quantity of digital assets that are held on custody for the issuer. Now, the issuer in these structures is designed to be bankruptcy remote. It's an SPV, and that's relevant because it tends to mean that there's a little less stress on the analysis of the validity, recognition, enforceability of the security. So the security is considered, let's say, more defensive in nature to reinforce the bankruptcy remoteness of the issuer, as opposed to being something that will necessarily have to be actively enforced on an insolvency scenario. But as I said earlier, from an English law perspective, there's no particular reason to think that valid security interests can't be created. To the contrary, I think people feel reasonably comfortable that you can create things, at least like charges, and we can also do title transfer arrangements. Next slide, please. So speaking of title transfer, what's happening, as I said in the last slide, is that the authorized participants are effectively transferring Bitcoin or other underlying crypto to the issuer at its order to the issuer's custodian, which is a sort of what they call in the Law Commission a sort of a state change transfer on chain, an on-chain transfer of the underlying digital asset. And that's being done in a transaction for value, I guess. So the authorized participants contributing crypto against delivery to it of a certificate, which can be analyzed as a normal financial instrument. And then it's in a much more traditional sale transaction, the authorized participant is just selling the certificate on to the end investor in exchange for the payment of the purchase price by the end investor. But if you look at the transaction between the authorized participant and the issuer, I mean, what that is effectively a transfer of a digital asset for value, and that tends to be documented in a relatively simple English law way, but without the actual factual transfer occurring, then we wouldn't say that there had been any valid transfer of title to the digital asset. It's essential that the digital asset be transferred through an on-chain mechanism. Whether or not a true sale opinion of any kind could ever be issued in relation to transfers of digital assets is an interesting question. It's not something that is a question that arises per se in the context of these ETC structures. No one really gets very concerned about it. The authorized participants who are contributing the crypto are considered satisfactory, reputable market participants. No one's concerned about their insolvency, and no one's really concerned about the irregularity of any transaction where they're contributing crypto in exchange for the certificates. There's no reason to think that's a problematic transaction. But in other structured finance contexts, you could certainly get into questions of whether some sort of true sale opinion is needed. There's no particular reason that you couldn't issue some kind of reasoned opinion based on the existing English case law concerning property, and also the sort of the legal thinking that's been developed in the Law Commission papers published to date. But it would be a reasoned opinion, and there would be areas of uncertainty, and it's not something that, for example, if it were a rated transaction, it's not something the rating agency would probably look at and say that's fine on a first read. And it's probably not the kind of opinion that internal legal counsel could look at and say, well, that's fine as well for my prudential purposes on a first read. They're going to be kind of unusual, or let's say there'll be opinions that leave zones of uncertainty and rely more heavily on reasoning and certain qualifications than what you would see with more traditional assets. And I don't think there's a market practice yet as to how those opinions should or will look. Next slide, please. So as I said earlier, the English law ETC structures tend to rely on relatively traditional forms of security, some combination of a purported charge over the digital assets themselves, but also usually either a charge or an assignment by way of security of rights as against the custodian, because remember, there will be an actual custody agreement and some sort of custody account maintained, and therefore some sort of the contractual framework that regulates rights and obligations between the custodian and the issuer, which can be the subject of security in and of itself. As I said earlier, market participants tend to place reliance primarily on the insolvency remoteness of the issuer, as opposed to rock solid analysis of recognition and enforceability of security as against third parties. And you sometimes see some risk factor disclosure about uncertainty of enforceability of the security, but nonetheless, reasoned opinions can be given. So it seems, as I say, that there's no reason to doubt that you can't create a charge or even a mortgage over digital assets. No reason to think that you couldn't do some sort of functional equivalent of title transfer security. There are some areas of uncertainty though, and I think we touched on it here, but I'll touch on it in the next slide. Jess, if you could move to the next slide, please. So one question is going to be practically, what's the enforcement strategy? If one has a charge as a matter of English law, then one would just have you'd be relying primarily on some sort of power of sale, but you wouldn't necessarily be able to appropriate the asset in the way that you would if the financial collateral arrangement regulations were to apply, which is why market participants are in favor of doing some sort of tweak to the MCARs to allow for appropriation. If one has to fall back solely to power of sale, then one has to think about the fact that there's significant volatility in the value of the assets. One has to work through how long it'll take to do that sale, how it's going to be structured, and what the risks are in that process in terms of end value realized. The other thing that people need to think through a bit more is how custody account structures will actually work. A lot of the thinking can be done by way of analogy to the custody of disintermediated securities. People have to think through whether they require segregated accounts kind of all the way through, which effectively means, when we say all the way through, in this case, it'll just mean all the way through probably to a custodian's own holding of a digital asset, where it is the so-called direct holder of the digital asset on chain for a single customer, as opposed to some sort of omnibus model where the custodian is a holder of various digital assets of the same general description, but holding them on trust for its account, its clients, on a kind of a pro rata basis. One has to think through account control, and again, the extent to which one can use existing frameworks that apply to securities to apply those to digital assets. Practical questions about how a change in the control will work. Who's going to hold the private key so that, for example, it can be operated immediately by the secured party in an enforcement scenario. I was going to mention as well briefly the question of conflicts of laws in a cross-border scenario. We touched on that earlier, and the question there will be, well, what's the proper law to kind of create a security interest over the underlying crypto and the accounts in which they're held, and what's the proper law to govern perfection, for example. And there aren't clear answers on those for the moment. There is a kind of a cross-border initiative in Unidroit to kind of formulate high-level principles of conflicts of laws. The UK is involved in that through representatives on the working committee, and there's going to be in due course an initiative in the UK to develop a conflicts of law framework in relation to digital assets. But for the moment, that hasn't translated into any kind of consultation paper. I think that covers, broadly speaking, what we were trying to cover in our talk today. And for once, I think we were trying not to overrun. So we've ended a few minutes just before 1 o'clock. That gives us some time for questions if anyone has any.
Yeah, if you've got any questions, there is a little on your control panel. There is an ability to pose questions if you've got any. We've just had one so far just saying, can we circulate the slides from 3 shows, which we're happy to do. I think this slide and this show and the previous one were recorded, so there's a recording available too. Conscious that not everything goes on the slide. Unfortunately, for the very first session, I think that functionality failed, so I don't think the first session was recorded, but we're happy to do that. Any other questions? No. Okay, well, look, thank you very much for attending today. If you do have any follow-up questions afterwards, you've got our contact details, you know who we are. So please don't feel too shy about whether it's questions on this session or previous sessions, please do shout. Thank you very much, and thanks, Jess.
Thank you.